All right. I want to thank you guys for being here today. I'm Melissa Isaac. I'm the legal director of the Fathers' Rights Movement. And today we're going to talk about the anatomy of a custody case. Now, I understand that everybody's case is very different. The facts are different. So we're going to really take an umbrella approach to the basics and the basic things that you should have in every case, whether you're a married father or an unmarried father, whether you're the plaintiff or you're the defendant. But these are the basic things that you should have in a child custody case, right? All right, so in a child custody case, you as a dad, you're in one of two categories. You're either a married father or you're an unmarried father. Now, when you're a married father, if you're married to a woman and she has a child, there's a legal presumption that you are the father of that child, as long as that child is born during the marriage. Now, even if you're separated and a child is born, you're still presumed to be that child's legal father, all right? Even if you look at the dates, and there's no way possible you could be that child's father, legally that you are presumed to be the father, right? But there are certain legal protections and legal responsibilities that come along with that. If you're a married man and the woman you're married to has a child, no one else can claim that they're the father of that child. Legally, you are that child's father. So if a putative father, someone who says, hey, I'm really the father to this baby, if they come forward, most states say that you have the legal right to say, no, I'm the father of this child, and claim paternity of that child. And then you could be in a contested action with maybe the putative father. Some states allow it, some states do not. But at least there's that legal protection in place that the law recognizes you as the father. There's some legal responsibilities that go along with that. All right, so the laws are different in every state, but there's usually some sort of a support obligation if there's a separation and a child is born. All right, so you do have some protections. They are rebuttable, but there are protections in place. Versus an unmarried father, there's no presumption despite the relationship status. You could say, but Judge, we've been together for 5 years, 10 years, 20 years. It doesn't matter. There's no legal presumption that you are the father of that child if you're not married. There's no legal protections. So if a woman has a child and you're an unwed father and you don't sign what's called the putative father registry or the responsible father registry, that child can be adopted by someone else, right? If it's not signed within 30 days of the child's birth, essentially you waive your right to contest any adoption. So there's no legal protection for you as an unmarried father if you don't sign what's called the putative father registry. And if you look at our pro se library, we should have some videos up about the putative father registry. So there are no legal protections, and there's no initial legal responsibilities, and we'll get to that. All right, so married father, if there's divorce litigation, it matters why the relationship broke down. Now, there's fault states and there's no fault states. Even in the states that are considered no fault states, basically where it doesn't matter why you're getting a divorce, the courts don't consider fault, they very much do still consider fault. It does matter why the relationship broke down. In cases of adultery, even in no fault states, you can still plead the reason for the breakdown of the marriage is because of adultery. If there's abuse, right? Or it could just be simply be irreconcilable differences. But it really matters why the relationship ended when you're married. So in cases of adultery, it matters why, even in a no-fault state again, for the divorce, because you could say, Judge, I'm a father, I've been a very involved father, I'm not the reason this relationship broke down. You're in a marriage, you're in a legal contract, and my wife, you could see if you're the man, you could say my wife ventured out, had an affair, and she broke this marriage. She broke down this marriage. There was lies, there was deceit. If you can bring that in, if you're a married father, and show the level of deceit, the judges may tend to be a little more sympathetic to you as a father in terms of custody, time with your children, things of that nature. Abuse matters. Most men who are abused don't report it. In fact, there's a lot of victims of domestic violence who are arrested as the perpetrator, even though they're the victim. So abuse matters, whether you're married or unmarried, but abuse matters. So we get asked all the time, should I file first? Is there an upside to being the plaintiff? Sometimes there is, sometimes there isn't. So if you're in a marriage and the two of you separate, but you're still living in the same house, and that happens, it may not be as urgent that you file first, right? But if you're in a marriage and there's a separation, and let's say you move out of the house, and you wait 2 years to file, well, what you've done is you've sort of established a status quo that the children, if they stay with her, the children are with her, and you see the children, I don't know, maybe every other weekend, a couple times during the week. You sort of set a precedent that you don't want to set. You say, well, we hear all the time, well, you know, I waited this long because I just wanted to see if our relationship could be reconciled, wanted to see if it would work. I don't want to put the children through all of that, but you can actually hurt yourself in a custody case later. So should you file first? If there's abuse and you're the victim, I wouldn't wait for that, especially if there's children involved, right? I wouldn't wait for that. So sometimes there's an upside to being the plaintiff, sometimes there isn't. In cases of adultery, if you have proof positive that your spouse is committing adultery, and if you wait too long, or if you attempt reconciliation, a lot of states have what's called forgiveness under the law. So sometimes we have clients who come in and they have proof positive of an affair. They have admissions, they have hired a PI, they have pictures, they have text messages, you name it. A lot of times the woman will attempt a reconciliation after consulting with an attorney, because if you reconcile with her, that's forgiveness under the law. Several clients we have had have attempted reconciliation, and as soon as they get that reconciliation, that forgiveness under the law, 6 months later, they file for divorce, they leave, and the adultery has far less impact, right? So I don't want you to misconstrue what I'm saying, that I'm an advocate of divorce. I certainly am not, but I'm not an advocate of manipulation either. So if you're in a situation where you're being abused, if you're in a situation where there's adultery, you have to really look close at the behaviors and, say, do I need to file right now or do I not? Okay? Men are the defendants 85% of the time. Men do not like to file. Men will talk to attorneys and they'll get their options, but they don't like to file. But sometimes it's in your best interest, it's in your legal interests, and it's in your interest as a parent to file first. Right? So they ask all the time, should I leave the house? If I leave the house, can she claim abandonment? And will it affect my custody case? So that's a very good question. It's a very fair question. If there is domestic violence, I do not recommend you stay in the house. If you are being abused, I do not recommend you stay in the house. We see, it is very common, we see a lot where there's domestic violence. You as the man might be the victim. When the police get there, guess who goes to jail? You do. You go to jail. So if there's domestic violence, the best thing you can do is remove yourself from that situation. But if you leave the house and if your children are there, you probably need to seek legal counsel and get something filed, because you don't want to stay gone too long and leave your children in the hands of an abuser. Because if you do that and too much time goes by, then the question for the court, the question for her attorney will be, well, if she's so abusive and if you're so concerned about your children, why did you wait 9 months to file for a divorce? Why did you leave your children with her for 9 months? And that's a question that's sometimes difficult to answer. Right? So if you leave the house and if you leave your children there, depending on the terms of why you left, you might want to consider filing. So can she claim abandonment? The answer is no. Abandonment is extremely difficult to claim. It's not. So sometimes a father will leave the house. There may not be a divorce filed for 2 months, and she said, well, he abandoned us. All right? If you have to leave the house, first of all, make sure your children are cared for. If you leave the house and the children are with her, make sure the children have what they need. Text messages. Do the kids need anything? Hey, I'm dropping off a check for $300. This is for extracurricular expenses, whatever the case is. Have a showing that you're still actively caring for your kids. But can someone claim abandonment after 2 months? I've never seen it, not in any state. So abandonment is difficult, right? So it's better for you to leave a dysfunctional situation, especially if it's a safety issue, and don't worry about abandonment. Will it affect my custody case? Again, it may, depending how much time goes by. So we've had men that have left the house, they've come in and say, look, I've been gone for a week, and she won't let me see my kids. So if you file a petition for divorce are asking for custody, joint custody, whatever the case, and you've only been gone for a week, that's a lot easier to litigate a custody case when you don't have that huge time span in there. Because if you leave again and there's 7, 8, 9 months between the time you file, between the time you've left, there's a lot of alienation that can go on in 9 months, right? You may not have access to your children as much access as you want to, and it could really affect your case. So will it affect my custody case? Yes, it can if too much time goes by. Allegations of domestic violence. A mere allegation can ruin your life. Can ruin your life, an unsubstantiated allegation. Now, domestic violence could be anything. We have found. It could be anything. I've heard 1,000,000 times, he's abusive and controlling. He's abusive and controlling. How is he controlling? He controls the pocketbook. He controls the money. He said, I can't spend money. I can't buy this. I can't buy that. But when you get into the nuts and bolts of the case, well, she might be a stay-at-home mother. Yes, I'm a stay-at-home mother. Well, the two of you operate on a budget. We do operate on a budget. All right, so let's go to the bank records. Let's look at the argument that you testified to that happened on January 1st. It was over you going to the casino. Yes. And at the casino, you spent $12,000. And he yelled at me, and it was very abusive. All right? So you can reframe anything. Because I'll tell you what, right? If I go to the casino and spend $12,000, I would expect my husband to be upset with me. That's reasonable. Is it because he's controlling? No. No. Is it because perhaps we have a budget and I exceeded that? Perhaps, yeah. So it's reasonable. So allegations alone, okay, you have to tear these allegations apart. Abusive and controlling, it's how do you prove a negative? He's controlling. He doesn't let me wear whatever I want, right? Well, let's look at this picture from Facebook, ma'am, right? These are chaps with no bottom in them, and you're carrying your 8-month-old son. You think you should get upset about that, right? So sometimes just because they say something and it sounds bad, you have to protect yourself from that. But let's go beyond just the proving a negative, proving abusive and controlling, these things that can just be said. There's no pictures, there's no hospital reports, it's just the allegation. Okay? You look at sexual abuse. When there's allegations of sexual abuse, that ball is hard to stop from rolling. Once it's rolling, it's hard to stop. You've got forensic interviews. You could be kept from your child, no contact for substantial periods of time, just based off an allegation. You can have coaching that's done to small children. There's children, it's been proven, it's been children who have disclosed sexual abuse that didn't happen, that did not happen, and it will ruin your life. So allegations of domestic violence are something that we battle in a lot of our custody cases. There's a very low burden of proof. Right? So married fathers will also, let me go back to the domestic violence. There was a Harvard study, and I can email the study to you, that said women initiate domestic violence 70% of the time. Women are the ones who initiate. Now, women may get hurt more often because if a woman starts a physical altercation with a man, the odds are that she is weaker than that man. So if there's a physical altercation, right, she might get hurt, she might get bruised. There's a lot of cases where a woman will jump on a man and he will grab her just to keep her away from him, and she'll have bruises on her arms. Then there's pictures, and guess who goes to jail? He does. He'll go to jail, right? But women are the one who generally initiate domestic violence. Document, document, document. I know you guys have heard this 1,000,000 times. You have to document. Record your interactions if your state allows surreptitious recording. There's one-party states, there's two-party states. For instance, in Alabama is a one-party state. So as long as one party to the conversation knows it's being recorded, you can record it without the other person knowing. You can't do that in Florida. Florida is a two-party state. So if your state allows recordings, I highly recommend that you record every single interaction. If there's a text message, that's great. You screenshot it, you save it. If it's an email, you save it. If there's a phone call, you record the phone call. If you don't, and I have so many clients that come in and they say, you wouldn't believe, she called me today, she threatened me, she told me she knew the judge, and I say, hey, you got it recorded, right? Nah, I didn't have my recorder with me. All right? There's a lot of conversations you can only have one time. You can't call her back and say, hey, remember when you told me yesterday? It's a big red flag. You can only have these conversations once. When I say record everything, if your state allows, when your phone rings, if you don't have your recorder with you, send it to voicemail, get your recorder out, call her back and say, hey, I'm sorry I missed your call. Record, record, record. If you can, okay? Don't break your state law. If you exchange child for visitation, you have the recorder with you. There's recorders that look like jump drives. There are recorders that look like keychains. There's video recorders that look just like lapel pins. Record everything. Can you openly record? Can you just wear a body cam and say, hey, look, this is how it's going to be? You can do that. What I find is if you do that, some women, it can be antagonistic, right? And it causes stress for children. Because you walk out, you say, oh, you recording me now? You gonna record me? Well, you know what? I'm glad you're recording me because now the judge can see you when you beat me, when you're abusive towards me. Sometimes it can flip around on you, okay? Because if she knows she's being recorded, one of two things is going to happen. She's either going to behave, right? But in my experience, it can bite you. And what I tell my clients, they say, well, gosh, I mean, I feel bad. I feel like I'm like tricking her. No, you're bringing the truth into the courtroom. You want to show the judge this is who she is outside of the courtroom, right? With a big body camera here, and I have a client who does that, and it's been difficult. It's been antagonistic, okay? But if you have a recorder in your hand, you go up, you knock on the door, knock, knock, knock. I'm here to pick up little Jimmy. She opens the door. Oh, you want to pick up Jimmy? Jimmy don't want to go with you. Jimmy's standing right behind her. Jimmy doesn't like you. She starts to curse at you. Say, listen, I'm not going to argue with you. I just want to get Jimmy. I'm just here to get Jimmy. Oh, yeah? Well, where's my child support? You're not taking Jimmy unless you give me child support, right? So you take that. You go in court. You say, I went up, Judge. I knocked on the door. I just said, hey, I'm here to pick up Jimmy. She said, Jimmy doesn't want to go with me. She started berating me right in front of my son, cursing at me right in front of my son. Right? She takes the stand. No, I didn't. Judge, when he came to the door, he knocked on the door, started calling me names, threatened to kill me, told me I'm going to take Jimmy, I'm never coming back. You push play, then what happens? Done deal. It's a done deal. And we'll get here, but what you want to do is you want to take the he said, she said off the table. You just take it off the table altogether. Because if you think about what is a custody case, right? Dad's on the stand. While we were married, I cooked dinners, I gave baths, I did homework, I took child to school. I came home from work one day, she's in bed with my best friend. They call the police, I get arrested, I go to jail. She's telling me I'm never going to see my son again. She hit me in the head, she did all this stuff. And she gets up there. I'm the one that did everything. He physically abused me. He called me names all the time. He wouldn't help bathe. He wouldn't help do homework. And he came home from work one day, and his best friend was there helping me with the plumbing because he wouldn't do it. And he jumped all over, and we had to call the police. Right? What happens if you have all that recorded? So the judge is saying, well, without recordings, without evidence, without documentation, the judge is like, I don't know you. I don't know you. What's the safe thing to do for a judge? Look, I don't know. Look, custody to mom, dad, you pay child support. That's the safe thing to do for judges, right? But if you can take the he said, she said off the table and destroy her credibility, you get a leg up. Judge would be like, okay, we just established who the liar is. Because in most cases, somebody's lying, right? You get two versions. I could see minor variations of the same story. People have different perceptions. But in a case like that, someone is lying. Someone is lying. And if you can show the judge who it is, it makes your case a heck of a lot easier, right? So if you can record, record. Now, if it's your house, you can have security cameras in your house. There's different types of security cameras. Yeah. There's many apps you can put on your phone that will record calls just when they answer. Be careful what app you download because sometimes you download an app and it's recording. If you get a text message, it'll stop you recording. Or if someone else calls you, it'll stop you recording. So if you want to be absolutely sure you're going to get everything, you can get an external recorder. But make sure the app that you do download doesn't stop recording. Right? Because, let me go back to that on that note. I had a case where my client recorded the whole conversation, about a 10-minute conversation. So for about 9 minutes and 50 seconds, all right, she berated him. I mean, called him every name in the book. The little boy's in the background, telling the little boy bad things about the dad. And my client is saying, just stop. Please, I just want to talk to him. Don't tell him that. Little boy starts crying. So the last 10 seconds, he just couldn't take it anymore. I mean, he read her the riot act. He told her what he thought of her. He told her what he thought the judge should do. So we get to court, and she plays this 10 seconds. Let me tell you what, judge looked at us like we were done. So I get up and I say, this conversation you played, was it 10 seconds? She said, no, it was a little longer than 10 seconds, but I was just fumbling with my recorder, and I was so scared to actually turn the recorder on, and so that's just when I turned it on. Okay. And when was this call? Call was on September 1st. September 1st. Okay, so I've got your phone bill here. I only see one call from him to you on September 1st, and it was 10 minutes. Is that the call? It might have been, but prior to that, I was just telling him, I was trying to fill him in about school and about homework and how his son was doing, and he didn't want to hear any of it. He just wanted to threaten me. Okay, all right. So, ma'am, if I played the entire 10-minute conversation for you, would you recognize that? You should have seen her face. So we played the entire 10-minute conversation. Guess who the child left with that day? With us, right? Okay. Without our 10-minute recording, okay, he probably would have went to jail. He probably would have went to jail. It was that bad. I'm like, tell him, I tell you, keep a cool head. He's like, I just couldn't do it anymore. But I don't think the judge could keep a cool head either after he heard the entire 10-minute recording. So if you can take the he said, she said off the table, it makes your case much, much better. Again, don't break state law. All right. Another question we get, do I have to pay child support while I'm still married? Maybe. Yeah, you might have to. You can separate, move residences, or you can even be in the same house. And a woman can file for child support, and you could be put on child support while you're still married, living in the same house. Absurd, isn't it? But yes, it can happen. Men don't like to file for divorce. So, have a client come in and say, but I got these child support papers, but I don't want to file for divorce. And if somebody doesn't want a divorce, I've never pushed anyone into a divorce. But can it happen? It can happen, even if you're married. Question, should we equally divide all of the bills? The best thing you can do is look to the status quo during the marriage. Right? If both you and your spouse you're equally gainfully employed, make about the same amount of money, then it's reasonable to ask the court, yeah, we should split the debt. Look to the status quo during the marriage. All right, so let's say that you make $50,000 a year, your spouse makes $50,000 a year. It's pretty reasonable to say, hey, judge, we're still living in the same house, which is happening a lot. We're still living in the same house, and we're just going to, we'll just split the bills. It's pretty reasonable to ask for. Where dads sometimes get themselves in trouble is they say, you know what, she cheated on me. We've been married for 15 years. She's been a stay-at-home mom. You know what, you pay the bills. And the judge is going to say, really? You want her to pay the bills? Well, Judge, she had an affair. She cheated on me, right? You want to look reasonable, okay? So look to the status quo during the marriage. You may have a spouse that has an affair on you, and you still have to foot the bills for a while. Judges will look to the status quo. And let me preface this too. I'm not standing here saying that I agree with everything. I agree with the law. I agree that, you guys just have to just eat a whole lot of stuff you don't want to eat while she gets away with everything. That's what I'm telling you. I don't think half of these laws are fair. I think the courts can be biased. But what I want to tell you is how you navigate your way through a system that is biased, right? Laws that aren't fair, and try still to get a good result, okay? So you have to look to the status quo during the marriage. Question we get all the time is, can I get a new bank account? Right? You usually want to do that prior to proceedings starting. So if there's a divorce on the horizon and you want to open up another checking account, another bank account, do it before the divorce is initiated. Because that bank account is considered marital property. You say, well, her name's not on it. It doesn't matter. If it was used during the marriage, the court can take jurisdiction over that bank account as marital property. Once it is filed, the judges and the courts get very upset if you modify those accounts unilaterally or without leave of the court. So if you're going to do that, do it before it's filed. Yes? So the question is, aren't some states allow discovery to go back for a year prior to the divorce? To see what husbands may or may not have. Yeah, and husbands and wife, they do allow that, but you can go further back than 1 year. So depending on length of the marriage, if it's a 25-year marriage, we might go back for 5 years, right? You're not necessarily limited, and we'll go over discovery. You're not limited just to 1 year, but yes, you can go back and you can get documents prior to the divorce. In fact, most of the discovery is focused on what is done prior to the filing of the divorce. Okay. All right, we get this question. Can she leave with the kids and keep them from me? Here's the lawyer answer. The courts will and should protect your rights as a parent, and we'll make sure the children have access to both parents if it's in the best interest of the child. The real answer, if your spouse is the type of woman to do this, then yes, you can, and you'll likely have to fight like heck to be a dad. All right? Best interest standard is a thorn in our side. And you read it, and it reads good. Well, who could disagree with this? Who's the jerk that's going to say, we shouldn't do what's in the best interest of the child? Who's that jerk? Who says that? Because it reads wonderfully, but it's applied in a very prejudicial manner. It's the application. Because again, like we talked about yesterday, there's no definition of the best interest of the child. It means whatever the judge wants it to mean. That's what it means. It doesn't mean anything. So we have all these scientific studies. We have a consensus. 110 of the most world-renowned social scientists have came to a consensus that shared parenting is the best interest of children. We have a definition of the best interest of children, but the courts won't adopt it. So can she take off with your kids? Yep, she can take off with your kids. She sure can. All right, unmarried dads. Does the reason for the breakup matter? Yes, it does. Adultery is less of an issue, though. Because adultery is the breaking of a legal covenant, a legal contract. You don't have that with unmarried fathers. So does the reason for the breakup matter? Yeah, but not so much adultery. Now, if you're living together, you're cohabitating, and you're not married, and your girlfriend or your fiance, your unmarried significant other, brings someone to the house and has sex with them in front of your child, then it matters. Then it matters that there was this other relationship. But you really more have to tie it into how this other relationship affects the child, right? The conduct during the relationship is the key when you are an unmarried father. You say, Judge, I've been living with my children. They're 5 and 7. We've been living together the whole time. I was there. I went to every pediatrician appointment. I cut the cord when the children were born. Here's a picture of me giving baths. Here's a picture of me at Christmas time wrapping gifts. Here, I fed them. Your interaction with your child is very important during a divorce as well, but it's the utmost of importance when you're an unmarried dad. So after the breakup, you have to stay involved. So it's common, especially with unmarried dads, after a breakup, is your contact might be cut off, where you can't be involved. You say, but you won't let me be involved, okay? So she might say, well, but he never even calls. He never asks to see the kids. I say, well, why don't you call? She sends me straight to voicemail. She won't let me talk to him. It doesn't matter. But you have to continue to make a showing. So we say, Judge, it's been 6 months since they broke up. We finally got a court hearing. Let me show you his phone bill. He called every day at 6 p.m. Can I talk to my child? Can I talk to my child? Can I talk to my child? Here's one call, and here's a text. Now, here's where you guys get in trouble. You call, and then call and call and call. Text, 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 text. Now you're harassing. One call, one text. That's it. That takes it off the table. Well, Judge, he really never asks. Well, ma'am, he calls you every day. Well, but he doesn't leave a message. What do you think he's calling you for? Okay. Also, record yourself leaving a message, because if you do leave a message, right, you say, listen, Jane, I just really want to talk to my son. Would you please have him call me back? I miss him. Tell him I love him. I really want to talk to him. You record that. Because if you get to court and say, well, he calls and leaves these messages, calls me horrible names, right? You don't think to record your voicemails? Record your voicemails, Well, ma'am, according to the phone bill here, he called you 10 times. You have 10 voicemails. Oh, yes, they were horrible. They were awful. You can play all 10. Does the judge say, So what we tell our clients is screenshot everything, because you never know when your phone's going to take a dive. You never know. Screenshot and email is the very best thing for us. There's a lot of apps where you can download your text messages, and it almost looks like a Word document. The screenshots are much better because it's at your actual device. It's easy for the judge to see, okay, I'm in gray and she's in blue. And they're more difficult to modify. So I've had these text messages, and I'm looking at them, and I'm looking at the phone bill. I'm like, this doesn't make any sense. It makes no sense. Like, Judge, I mean, she could have created this in Microsoft Word for all we know. So the best thing to do is actual screenshots, and just keep up with your screenshots. As far as the recordings, if you email everything to yourself, it doesn't matter if your phone breaks, everything will be in your email address. So if you get some evidence, email it to yourself, because that happens all the time. Evidence, good evidence, case-winning evidence is lost all the time. So email it to yourself. So the question was, do you recommend setting up a separate email just for your court case? Yes. Another word of advice, change your passwords. You guys, change your passwords, okay? I will say this, women tend to be very resourceful, right? Now, my husband, I know every he uses the same password for everything, okay? I can get into any information, anything I want to get, I can get, because he uses the same password, right? Change your passwords. Let your lawyer pick your password or something. I don't know. You guys are creatures of habit. That's what we kind of see that. So you've got iCloud now. All right. Sometimes she leaves with the iPad. Guess what? The iPad is logged into your account, and guess what she's doing? She's reading all your emails between you and me. It happens. There's a lot of that, and it's against federal law to do that, but they do that. It's becoming more and more common too. So, and now that there is starting to be litigation over reading emails. You know, you're not supposed to be in these emails. So, but change your password, get out of your iCloud account, right? So I uploaded everything to my iCloud account. It's not here. I don't know why it's not here, okay? Because you got your password. She's taking everything. Change your passwords. If you create a new account, you can get a Gmail account. There's a lot of resources within Gmail, a lot of Google Docs, a lot of storage and things like that. But yeah, we do recommend you getting another email account. Yeah. Okay, so she's correct. So she's saying is when you change your passwords, unsubscribe out of your other devices. Like, make sure you log out of all of your other devices, right? Because it's so common. You guys don't do that. And then all your information, she sees it. She sees your conversations in real time with your witnesses, with your lawyers, everything, absolutely everything. So make sure you really protect yourself and keep all that stuff confidential, okay? All right, should I file first? If you're an unmarried dad, you probably should file first. Other than money, which you can file for child support. Okay, so child support proceedings and custody proceedings for unmarried dad, these are two different things. So should you file first? Probably. If you want to have any legal rights to maintain a father-child relationship with your son, with your daughter, you probably should file first. So if you're giving your ex money every month, here, you know, you're not married, but you broke up, you're giving money every month, what is her incentive to file anything in court? She has 100% of the legal control. She has your money. She dictates when you see your children. You're not on school forms. You have no right to any educational materials, no right to medical information. You are no more this child's mother or father. I'm sorry. You are no more this child's father than I am. You can say, well, I'm on the birth certificate. It doesn't matter in some states. Unless there's a legal adjudication that you are this child's father, being on the birth certificate is not enough. So should you file? Yeah, you probably should. Because if I'm not married, I'm the mother, and I'm getting money, why would I go file and relinquish some of these legal rights? You're not going to do it. So again, you get in the situation where a lot of you guys give cash. Don't give cash. You're paying cash. Here you go. Right? And then it breaks down. Well, we've been broke up for 6 months, and she was pretty good. I was getting my kids almost every other weekend, but I didn't want to rock the boat. She wanted more money for this. Some women, by the way, will only accept cash. Huge red flag. I've been paying. All of a sudden, guess what? right? New boyfriend comes in the picture. You're out. Then you have to file, and you say, well, I want custody. I question her fitness as a mom. But it's been 6 months. You haven't been paying any support. Oh, no, I have. Do you have any receipts? No, but ask her. I've been paying her. You ask her. I've been getting nothing from him. Then guess what? The courts can go back and order retroactive child support. Never mind, you already paid it. You tack on interest to that, right? So should you file first? Now, you probably should. Now, if you're in a conversation with your child's mother, you're an unmarried dad, and she's like, look, let's just keep it out of the courts. Hey, that's great. I'm all about keeping it out of the courts. But let's put something down in writing real quick, just so we have an understanding. So if anything comes up, if she won't put something in writing, I do recommend you filing with the court. If she says, no, that's cool, let's put something down, then you're probably okay. But you want to protect yourself too, because if you don't have legal protections, we all know what happens to dads with no legal protections. They get drugged through the courts. And a lot of times when you first break up, you don't really think about this, but what happens when new relationships begin? You might have a new boyfriend who doesn't like you. Well, why is he coming over here? Well, why can't you guys just exchange at McDonald's? Why do you everything could change? And all of a sudden, we have guys that come in and they say, we've been broke up for 2 years and I don't know what happened. All of a sudden, she's like, you're not seeing, we're not doing week on, week off anymore. I have no idea what happened. Nothing changed. Well, I said, did you get married? Yeah, like 2 weeks ago, but did she get a new boyfriend? There's a change in relationship status somewhere usually, okay? So there's a lot of things you don't think about, but that's one thing you have to think about. So should you file first? Yeah, you probably should to protect your legal rights. Should I leave the residence? Oh, maybe, okay? Again, for domestic violence, if there's domestic violence, I always say yes, leave, right? Especially if you're the victim, call the police, you guys. Call the police. But should I leave the residence? Now, if you're not married, and what if it's your residence? If it's your residence and she won't leave, and she wants to stay in your house, you could probably anticipate some domestic violence allegations coming up. Because we have had dads who are not married, who were restrained from their own house because of domestic violence allegations. Again, allegations. So, should you leave the residence? It depends. If there's domestic violence, even if it is your house, yes, but go to the police, make a police report, and cover yourself. But a lot of times you're not married, but both your names are on the lease or whatnot. But so should you leave? Maybe. Again, allegations of domestic violence, a very low burden of proof. Can she keep the kids from me? Yes. Yes, she can keep the kids from you. You don't have that same legal protection. You are not the presumed father. Remember, even if you're on the birth certificate, that doesn't mean that there's anything in place saying that, yes, you can see your children on these dates and these times. So can she keep the kids from you? Yes, she can, absolutely. But my name is not on the birth certificate. Again, not an adjudication of paternity. I'm going to say there's always a sense of urgency because your children are always getting older, and you don't know what they're being told. The question was, if there's a breakup and there's already a significant period of time that has lapsed, does that urgency still exist? From a strategic standpoint, I guess, if 2 years already went by and you're claiming that she's not fit, the judge might say, well, then why did you wait 2 years? And that's exactly what they're going to say. Why did you wait 2 years if she's not fit? Again, depends on circumstances. Now, there's some dads who are in the military, they get deployed, and there's really nothing that they can do. So if you're a dad and you can give a reasonable explanation as to why there was this 2-year period, okay? But even though a judge might question you, the other attorney might question you, you might have to explain yourself, that in and of itself is not enough for them to say, no, you can't be a dad to your kids. That's not enough. Let's say that you had a drug problem. Let's say you had a drug problem, you went to rehab, you got out, you got a good job, you're the ultimate comeback kid. You rehabbed yourself. Judge might say, you could say, for me, it was my sacrifice to my children. I did not want to be around them when I was in that state. I was not at that time, I couldn't be a good dad. But let me tell you what I've done in the meantime. So if you can explain the reason for your absence, take responsibility for it. Just own your actions, if that's what it is. But sometimes there's explainable reasons for that. Yeah. All right, starting the process. You can file your complaint or your petition. Those two things are used interchangeably. Each state has jurisdictional grounds that you have to meet. Okay? Generally, you have to be a resident of the state that you're filing in for at least 6 months. Okay? You want to check your state law. Sometimes it's less if it's a child support matter, but generally if you're filing for divorce, you have to be a resident of that state for at least 6 months. You must be at least 18 years of age. Again, check your state law. Alabama is 19, but generally most states is the age of 18. Now, the place of separation matters if you're a married father. So let's say that you live in Texas and you end the marriage, the separation rather, it begins in Texas. So you're living in Texas as husband and wife, you break up, you move to Louisiana, she moves to Alabama. Okay? Neither one of you lived as husband and wife in Louisiana, neither one of you lived as husband and wife in Alabama. Who has jurisdiction over this divorce? Texas might have jurisdiction over this divorce. Right? That's where it happened. Or sometimes, let's say wife leaves husband in Texas, a wife moves to Alabama, husband's still in Texas, wife files in Alabama. Alabama has no jurisdiction because the place of separation matters. It will stay in Texas. Right? So it happens a lot with our military clients where they're somewhere, they separate, they want to give it a trial run, and trial runs, well, we'll just be separated for a while. Military does that because there's benefits with being a military spouse. If you're a separated spouse versus a spouse in an intact relationship, your ID card looks the same. Medical benefits are the same, right? Shopping at the PX and the commissary, it's all the same. So military spouses are more amenable to separations because they keep their benefits. But in the meantime, people move around to different states, right? There's also rules for military that if you're in Alabama because of military orders, you don't have to submit yourself to the jurisdiction of the courts in Alabama because you're there because of military orders. You're there because the government made you go there. So jurisdiction might be in a state that you don't even live in anymore. So there's some jurisdictional grounds that you have to meet to file a petition in a certain state. Okay? So let's say you're in the military and you have property in other states, you have children in another state, and a divorce is filed against you in Alabama. You can say, no, you can give me a divorce. You can move me from the status of being a married man to a single man or a divorced man, but you're not going to distribute my property. You can do that. So a state might have jurisdiction over your status as a married man, but they can't distribute property, they can't award custody, they can't make you pay child support. Okay? So there's some jurisdictional things that come into play when you look at where you're going to file. So this is a basic complaint, and you have the style is the top, okay? So you have what court you're in, you have the names of the parties, you have a case number, and you have what this is. This is a complaint for divorce, okay? This one, you identify the husband is over the age of 19 years, has been a resident citizen of Montgomery County, Alabama for more than 6 months before the filing of this complaint. You allege the same thing with her. Married mom, over the age of 19, a resident citizen of Alabama, been a resident for more than 6 months. You have to show the court, I meet the residential requirements to file for relief in this court. You say where the parties were married, when they were married. You have to establish that a valid marriage exists, right? Because the court can't take jurisdiction of something that doesn't exist. If there's children, the children name the petition. Okay, the parties had 2 children. Some states you can put their full names, some states you can only do initials. Regardless, you identify the children, you identify when they were born, and you look at property. The parties acquired certain property during the marriage. Now there's community property states, and there's equitable distribution states. Community property states, look, if it was acquired during the marriage, 50%. You just split it down the middle, which is actually pretty cut and dry way of doing it. Then you have the equitable distribution states. The vast majority of states are equitable distribution states. So basically, the court doesn't look at what's equal, they look at what is equitable. In the eyes of the court, what is equitable? So you might have an estate worth $200,000. You as a man might be awarded $40,000 worth of assets in that estate. A woman might get $160,000 because that's what the judge thinks is equitable. So the courts look at a lot of things. They look at your income. They look at your ability to earn. They look at the contribution during the marriage. Now, inheritance is generally kept out of the marital estate, right? Sometimes it's in the marital estate. If there's inheritance and you want to keep it from being distributed by the court, you have to keep it in a separate account in just your name, and you probably don't want to commingle it with marital funds or use it for the benefit of the marriage. So if I inherit $1 million, and every month I draw $2,000 off of that inheritance, every month. So if I get a divorce, that's considered income. That $2,000 a month is considered income. I can say, well, no, that's inheritance. Inheritance is not, you can't divide the inheritance. Well, they don't have to divide the inheritance. But if I'm having to pay child support, they can use that $200,000 a month that I've been customarily getting and bringing into the marriage and using for the benefit of the marriage in a child support calculation. Okay? So if you inherit a home and you and your family move into the home and that becomes the marital residence and it's used for the benefit of the marriage, it loses its protection as inheritance and now becomes marital property. Right? So you can inherit a home, and 5 years later, you could lose the entire home to your spouse. That is a possibility. So again, with inheritance, if you don't want it to be part of the marital estate, keep it separate. Don't use it for the benefit of the marriage, or get a prenup. Get a prenuptial agreement. Now, if you inherit during the marriage, you can still do an agreement. After you're married, everything has to prenup. You can do a postnuptial agreement to say that, okay, even though this will be used for the benefit of the marriage, it won't. The parties both agree it won't lose its inheritance protection. It won't be distributed during a divorce. Okay, people don't like to do that. During marriages, people don't generally like prenups, but they really do help you. All right. All right. So, one thing you look at debts. You say, hey, look, we've acquired debts. We want those equitably divided. All right. Now, one thing that people do, that pro se litigants do, is they try their entire case in their petition of their pleadings. This is not the place to go into detail. Right? My mom said that her cousin told her that she was at Walmart the other day. Now, this is not the place for that. This complaint is you meet your jurisdictional requirements, and you're just saying to the court, look, this is what I'm asking for. Okay, you don't have to go into detail. Now, sometimes we do go into detail. Sometimes it's a little bit of detail, like in this one here. It says, the wife has emptied the party's joint bank account and refused to contribute to the funding of the marital expenses. As such, the husband requests that the wife immediately return the funds to the joint account and asks his court to enter standing orders where neither party shall spend, dispose, gift, hide, or in any way conceal the marital assets. Okay, so we're still asking the court to do something, and we're giving them a brief reason why we're asking for that. Because what we're doing is we're asking the court to give us relief before a hearing, right? Before a final hearing. So if you're going to ask the court to do something, if you want a custody order, or a parenting time order in place before the hearing, give a brief reason why. Judge, this is what's happening, so we're going to need some sort of a temporary order. But you don't want to try your entire case in your complaint, okay? This is just sort of a quick and dirty, hey, I'm meeting the jurisdictional requirements, and this is what we need to do with our stuff, okay? So here, this case was incompatibility of temperament, irreconcilable differences, there's a breakdown in the marriage, okay? Now, in red, you really can't see it, but it says the husband has retained the services of the Isaac law firm, and adverse that the wife should be responsible for reimbursing the husband a reasonable attorney's fee. If you don't ask for it, the judge can't give it to you, okay? So how often do you think that judges really order women to pay us attorney's fees? Hardly ever, hardly ever. But we still ask for it. Because if something egregious comes up, and we say, oh my gosh, judge, we need some attorney's fees, Other side could say, well, Judge, look, they didn't ask for attorney's fees. They didn't plead that. The court can't give you what you don't ask for. So, of course, if you're a pro se litigant, you don't necessarily have to ask for that. But there's a lot of times where you have an attorney and they don't ask for that. And lightning could strike, and we have gotten attorney's fees. We have gotten awarded attorney's fees at the trial court level, at the appellate court level, but you have to make sure you ask for it, okay? Now, the last sentence, the husband should be awarded such other, further, or different relief to which he may be entitled, okay? So that's sort of the catch-all phrase. So if something pops up that really, let's use attorney's fees. We can use that one too. If something happens that's so egregious and the other side says, well, Judge, this isn't before the court, you can say, but Judge, I asked for any other relief that you feel in good conscience I should be entitled to. The judge could say, well, they did plead that. They did plead that, and I do find that he should be awarded attorney's fees. Okay? So you want to give the court as much discretion as possible to give you what the court thinks that you're entitled to. All right, so a complaint for unmarried dads, same thing applies. Okay? Time limits for residency requirements, but this is different because you have to allege paternity. You ask for there's certain types of relief. You have to serve the other person. Okay? This is with if you file a petition, you're married or not, there has to be personal service. Usually, someone comes to I'll be at a private process server, the sheriff knocks on their door, okay, gives them the process service. You can do it by certified mail in some states, okay, but there has to be service there. We'll go over discovery, we'll go over name changes. So this is a real petition that we filed, a petition to establish paternity and custody. First thing, again, the father's over the age of 19 years, been a resident citizen of Clark County, Alabama for at least 6 months before the filing of his petition. Same thing with mother. That while the parties were never married, they were involved in a sexual relationship, whereas they bore a child who was born on December 30th, blah, blah, blah. Okay? The father avers that he is the biological father of said child and wishes his court to make a legal determination of such. We're saying, look, Judge, we meet the jurisdictional requirements. We're alleging a relationship here. The relationship resulted in a child. We're asking you to make this man the legal father, right? There has to be a adjudication of paternity. Okay? The father avers that the minor child should carry his last name. If you're an unmarried dad, you have to ask the court to do that. A lot of dads don't realize that when they're pro se. They just go in there and say, hey, Judge, look, I mean, we're boyfriend, girlfriend, and I mean, the kid's mine, Judge. I mean, look at the eyes and look at my eyes. I mean, look, okay? It's not enough, okay? You don't think about things like, what about the child's last name? So after the fact, sometimes men will come in and say, well, I mean, I got it every other weekend, but the last name is Smith. I want the last name to be, Anderson. Well, it's hard to go back years later and do that. So you want to do that at the time that you're trying to establish paternity and custody, okay? Father avers that his name should be placed on the minor child's birth certificate, okay? Make sure you add that in there. You wouldn't believe that the custody orders or that are entered, maybe giving dad visitation, but there's nothing mentioned about the birth certificate. Then you're going back later and jumping through other hoops to get your name on the birth certificate. So go ahead and put that in your complaint. Okay? So now we're alleging the relationship. The father was an active participant in the pregnancy of the mother, supporting her fully and completely until the mother, for reasons unknown to the father, decided to disallow the father to be fully involved in the life of the baby. Okay? He was a fully involved, engaged father. Now, we're telling the court, this is the petition, dad's fully involved. We don't have to go into everything. We have to go into, he's the one that bought the pregnancy test. He went to every OBGYN appointment. Look at his Facebook page. It's full of ultrasound screenshots. Here's all the receipts for diapers. That's later down the road. In your petition, you make more general versions. Okay? So we say that the father is a fit and proper person to exercise custody of their minor child and request that this honorable court grant him equal rights and equal time with his child. Okay, so a lot of women read that and they're like, you're trying to take my child away. No, it says the father is a fit and proper person, okay? Is a fit and proper person to exercise custody, and you are. Then we say equal time, equal rights, right? The father avers it is in the best interest of the minor child for her to be in the care and custody of both parents, so long as the mother does not continue to act in ways which are contrary to the minor child's best interest. So the question was, is there any strategic advantage to asking for full custody and then maybe hoping the judge will rule somewhere in between? Now, you have to check your state law, because in Alabama, if neither party asks for joint custody, shared custody, the judge does not have to consider it. Right? So if we go in there, and that's a very common misperception. You go in there and you say, well, I'm going to ask for full custody. Okay, then she asks for full custody. Now, first thing that does is it lets the judge assume these two can't get along. These two can't co-parent. So a lot of lawyers do that. There was a father's rights attorney who told me, well, what I do, I just ask for everything and then hope maybe we settle somewhere in the middle. So if you want to cause contention, go ahead and serve this mother with child support papers saying, I'm taking it all. So in here, now this first sentence reads, the father is a fit and proper person to exercise custody of the child, and he is. He is a. We're not saying the only, we're saying a, but then we qualify it by saying that it's in the best interest of the child to have equal time and equal rights. Okay? So do I recommend that? No, I don't. I don't recommend that. I think it's an adversarial system, and right out the gate, you make it as adversarial as you can. You can use the parental alienation vocabulary. You can. I would be careful with that, because parental alienation, that term, is thrown out there too much. There are very few experts in terms of parental alienation. So if you're going to put that in your petition, you better have some pretty strong proof, or maybe have an expert in the wings. But so there's some alienation in this case, right? The problem is we're dealing with a baby. It's hard to prove alienation with a baby, other than she's withholding time, because babies don't, say, hey, Dad, I heard you were a real jerk to Mom before I was born, so I'm not going to come see you anymore. That we don't have those behaviors yet because we're dealing with a baby. So that's why we said here that it's in the best interest of the child for her to be in the shared care of both parents, so long as the mother doesn't continue to act in ways which are contrary to the minor child's interests, which are keeping Dad away from the child. Yeah. So his question was, should we just go ahead, and I'm summarizing, should we just go ahead and plead a parental alienation? And he was saying, well, don't usually use the terms narcissist, borderline personality, maybe bipolar, because then you really do lock yourself into proving these things. You lock yourself into bringing experts in, but rather use the behaviors. And that's exactly right. That's exactly right. Because a lot of times with pro se litigants, you're writing for your emotions, okay? She's crazy, her mom is bipolar and she is too, but the judge is kind of like, oh gosh, thinking, oh gosh, here we go. You don't want to lose any standing. So what do narcissists do? They fail to take responsibility for their behaviors. They will do something and they'll blame other people for it. They use their children as pawns, as weapons. So he's exactly right. You want to put the behaviors in there and stay away from labels. Because unless you are a psychologist, or unless your spouse has a history of undergoing psychometric testing, where in the past she's been diagnosed with narcissistic personality disorder, stay away from that, because you look spiteful, you look angry, and you look like you just can't get along. Okay? So, yeah, stay away from labels. But very good point. Very good point. All right. So in here, again, we're not going into too much detail, but we're giving the court an overview that the father avers that he has already missed out on precious, irreplaceable moments with his minor daughter, and avers that absent intervention by this court, he will continue to be restricted from his child's life. Okay? We just said about 6 months worth of what's been going on, but we condensed it down so the judge has a general idea of why we're filing this. Okay? That the father alleges that he has made attempts to parent directly with the mother, and the mother has not been receptive to his efforts. Like, Judge, I've tried. And what really works in courts, too, is you go in there and you say, what attempts have you made to see your child? Well, I waited 3 months before I filed this. I called every day, text messages. I went to the school. I went to the daycare. Daycare kicked me out. She called the police and said that I was threatening and peeking in her windows, but Judge, I worked the night shift. I can show my records exactly where I was when she did this. But basically you say, Judge, look, I've tried. I'm here because I've tried everything and I'm here. Okay? Because you want to show that you tried. You want to show that you're making the effort, because, and we'll get there, but one thing that courts look at when they look at custody determinations is which parent is likely to facilitate a relationship with the other parent. Okay? Well, I say they're supposed to do that. I don't know that they always do. But you want to make a showing that, look, I've tried. I'm being very reasonable. Okay? Okay, so the best interest standard is in every state, right? So one of the factors, and the states might word it differently, but it's usually a factor in every list in every state, is basically which parent is likely to facilitate a relationship with the other parent. Okay? So you're going in there, let's say the child's with you, and every day at 7 o'clock, you Skype mom, say hi to your mom, hey, mom says, what did you say? Oh, Daddy took me to the zoo. Okay. You're reaching out. If it's her birthday, you're making cupcakes for her. You don't want to cook cupcakes for your ex? You could care less, but you're doing it for your child, right? Okay, so you're doing things you don't have to do to go above and beyond to make sure that even though your child is with you, that they're maintaining a good relationship with the other parent, even though they're in your physical care. Now, that's one thing the judges are supposed to look at. It doesn't, most courts have no duty to make findings of fact or to give you a reason as to why they rule against you or don't rule against you or do rule with you. They don't have to give you those findings. But at least you're making a showing to the court that I'm trying to do what's best for my child and facilitating this relationship. And his comment was that he doubts that people are really aware of this nationwide when they're going through this litigation. Yes, and it does matter. What he's saying is you speak well of your child's other parent, right? You never badmouth your child's other parent to your child. Never do that. Always try to facilitate that relationship, even if you don't want to, because that's that child's mother. Your relationship with your child's mother has nothing to do with your child's relationship with their mother. So facilitating that shows that you're making the best efforts. Yeah. Is it a bad reflection upon a parent who is seeking full custody? Okay. Yes and no. The social norms in place right now, if a mother doesn't seek full custody, people are like, oh, okay. A mother is almost expected to do that. And I think some women will pursue full custody, and they tell the dads, look, I don't care, after this is over, we'll do week on, week off. But I can't agree to it, though. But I can't agree to it. But I'm a good dad. I know you're a good dad. Look, I'm not trying to take them from you. My lawyer said, a lot of times, my lawyer said after this is over. But they want that designation of sole custodian or primary custodian. So, but let's turn it around as a dad. As a dad going in there and saying, I want full custody. Right? If you're going in there as a dad saying you want full custody, you better have some pretty good proof that she's a bad mom, or the court will probably look at you as being unreasonable. So what she's saying, for the recording, is what you can do to get around this asking for joint custody is make the allegation that the husband or the father avers that he should be awarded at least equal time, at least equal decision making. That way, if something happens later, you can say, well, Judge, we need full custody, and this is why. If you allege that you should have equal time and equal rights, and something happens, she gets into drugs, or something happens, you can always amend your pleadings and then at that time ask for full custody as well. So, but it's very important that if your child's a good mother, just for the health of your child, that you ask for half time. Okay, so the question was, the statement was made that if you're a dad asking for full custody, you should probably have some pretty good evidence of unfitness or as to why you're seeking full custody. But mothers ask for full custody all the time, and they're not seen as unreasonable because there's a huge double standard that exists. There's a society standard where there's dads that come in and they say, I'm just, my wife wants a divorce, and I just need you to let me know how much child support I'm going to pay. So, well, you don't want to share custody? I'd love to share custody. But this is Alabama. They're not going to do that. Well, no, they might. So a lot of men automatically assume, because of the social norms, that they're going to be paying child support. So we have judges on the bench who were attorneys. Most of these judges, practiced law for some decades under this old best interest standard, under when the women always get custody. So they take the bench and they just continue the status quo. So you're absolutely right. It's a double standard, and that's part of the bias in family courts. So the question was, do you see any negatives in the approach of if you have a spouse who will not co-parent with you, won't work with you to raise the child together? you've seen a downside of going ahead and seeking full custody, and then maybe after you get full custody, then working with her on a more modified schedule. Right? I do see problems with that, because the reason that the two of you are in court fighting over custody is because you have a difficult time co-parenting. Now, you could say, she won't talk to me, she won't respond to my text messages, she won't tell me when doctor's appointments are, she's incurring expenses, and, she's saving them up for 6 months and hit me all at one time, so I got to pay them all, within 30 days. There's things that she's doing that are making it difficult for me to be a dad. Okay? You say that. She comes back. I don't talk to him because he's abusive when he calls me. I don't tell him when the doctor's appointments are because last time he went to the doctor's appointment, he made a huge stink, embarrassed us both, and we had to leave without the child's medicine, or whatever the case is. That's the easiest way to get into a unnecessary, I hate to use the word pissing match, but that's what it is. And it causes a lot of contention because she's not going to say, oh, you're right, I've been difficult, I'm just going to go ahead and give him custody. Okay? That's likely not going to happen. I think your better approach is this, is that you have the social science behind you. Now, co-parenting is less becoming relevant, and parallel parenting is now becoming more relevant. Because with co-parenting, there's a lot of discussions. We're going to talk about this. We're going to agree on this. We're going to sit down. We're going to look at the pros. We're going to look at the cons. And that's too much to ask for some parents. They can't co-parent. So parallel parenting is more in place for high conflict divorces, high conflict relationships, where the judge says, okay, I understand that the two of you can't really make decisions. So I tell you what, Dad, you're going to have decisions when it comes to schooling and extracurricular. Mom, you're going to make the decision when it comes to medical and religion. Okay? So, Dad, you're going to have to at least email Mom and say, hey, this is the issue, this is what I think. Mom might email back, and you have to take her wishes into consideration, Dad, but you got the final say. So, and a lot of parents in high conflict situations will communicate through like the family wizard apps. There's different apps, we'll go over those. But every communication is recorded. They know it's recorded. And these apps are set up pretty much for the courtroom. So your better approach, again, she can be difficult for you, but be a good mom. So your better approach is to take the parallel parenting route, use the scientific literature, scientific research that we have in place, and say, even though we can't get along, even though we can't co-parent, let me tell you why shared parenting is still in the best interest of this child. And you can take the research, you apply it to your case, and you can use the apps and go the parallel parenting route. And you may not know this, he's saying that might work for some people in a high conflict situation, but he's saying in his situation, it might be better for him to go for full custody. I don't know the facts of your case, and it may. But parallel parenting was really born out of because high conflict parents couldn't co-parent. Yeah. Okay? All right, so let's move on. Again, we put this paragraph in here that the father requests that the court grant him such other further or different relief to which he may be entitled. Put that general paragraph in there so if the judge wants to give other relief, the other attorney says, hey, judge, this isn't before the court, they didn't ask for this, it could fall under that paragraph. Now, discovery. Discovery is extremely broad. The rules are written where it's very liberal, but it's discoverable, okay, as long as it reasonably is calculated to lead to, relevant information, or admissible information. It's pretty broad, okay? But discovery is a legal process by which you can obtain information that's otherwise personal and protected. So if someone wants to get a copy of my bank statements, thank you, okay? You can't just walk into a bank and say, hey, I want a copy of Melissa Isaac's bank statements. You can't do that, right? But if I send a discovery request to my spouse and say, I want a copy of your bank records, they're reasonably accessible to him. I don't know of a single bank where the records aren't online, so he would have to give me a copy of those bank records, right? Telephone records. You can't call Verizon and just ask for a copy of anybody's phone records, but through the discovery process, you can get these phone records. You can see what time they're calling, what number, how many times. Now, you can't get the text messages because cell phone companies only keep an actual copy of the text message for like 6 to 15 days and then they delete it. right? So you won't be able to get necessarily the copy from Verizon or from AT&T. But if you ask them for copies of their text messages and they delete them after you've asked for it, well, that's against the law, okay? It's hard to prove. But when you ask for it, if it's on their device, they're supposed to preserve them, screenshot them, and give them over to you, okay? Now, bank statements, okay, you file what's called a request for production of documents, and you ask for all these things. Bank statements are wonderful because, especially in alimony cases, they're great, right? Or, child support cases, you say, a mom might say, well, I don't make but $1,300 a month. Then you get their bank statements. They're like, well, wait a minute. There's $1,300 deposited every 2 weeks. Well, I told you my paycheck was only $1,300. No, that's not what you said. There's a big difference between $1,300 a month and $2,600 a month. Okay? So you can get these bank statements, and the bank statements will show you all the incoming deposits. You might have a deposit from an unknown source. You need to find out who that's from, who that deposit is from, who else is giving them money. Also, bank statements tell you where they're spending their money. So I had an alimony case. It was a military case. Woman testifies. They didn't have any. He wasn't giving her money. They had no food. She was a GS employee. She had a federal job. Her daughter was 21 years old. Not my client's daughter. But she said, we had no food. We were starving. She goes, I was going from house to house to house, begging for food. Wow. And when was this? This is when he was in Korea. All right. Well, let's look at your bank statements. Let's just look at the 3 months while he was in Korea. How much money did you spend eating at restaurants? I don't know. Every once in a while we would go out. So I look at it here. Let's look just the month of January. Does $1,463, does that sound right? No. Well, let's go line by line. Go down these bank statements. Oh, Charlie's, Applebee's, every day. Doesn't look like somebody's starving to me. All right, so let's put aside the food, the eating out. Let's jump to the tattoos. How much did you put out in tattoos? Well, my brother died. Okay, let's go back to the tattoos. I had to get a tattoo because my brother died. That was how I cope with things. Okay, so you're starving to death, you testified. But you still spent $850 on tattoos. Yes, it was mental health, it was therapy. Okay, all right. Let's go to your Amazon purchases. Let's go to your iTunes purchases. So you can take these bank statements and just tear them down. Because if I'm a judge, and the judge hears, gosh, this woman, she's crying. She must be upset. She's starving to death. If I'm a judge, I'll be like, this woman's not truthful. Get the bank statements and tear them apart, right? Your bank statements are good. Say, Judge, he never buys anything for this baby. Nothing. Keep your receipts also, but your bank statements. Well, Judge, here's a receipt from Walmart. He's buying diapers, wipes, baby clothes, baby food. Well, I don't know, it's for my child. Okay, come on, all right? But keep your evidence, keep it there. Go to your bank statement. Look, Judge, here's where I spend my money. I was at Carter's. This is where I bought food. This is at wherever you buy baby stuff from, okay? Keep your receipts, keep your bank statements. Bank statements are a plethora of information, yeah.
For transactions.
Okay, keep your Jack Daniels purchase off of the same receipt as your diaper purchase, okay? It's not against the law to drink. If you guys are over the age of 21, buy beer and drink it. Don't care, okay? Just don't break the law. But you're in family court. If she says he's an alcoholic and you submit a receipt with diapers, wipes, and Jack Daniels, okay, keep your purchases separate. If you know your receipts are going to go to a judge, just try to keep your receipts separate. It's much cleaner for us, much cleaner for you, okay? So yes, good point. All right, so phone records are great. If you think that your spouse might be having an affair, odds are there's, 30 phone calls in 5 days and text messages at 11, 12 o'clock at night to the same number. Your lawyer can find out, you could probably find out, who that number belongs to, all right? If it's, Steve, who she works with, oh, we're just friends. Really? Huh. Because it looks like you got out of my bed to text with Steve 35 times between 11 and 11:35. We were talking about work, okay? Judges aren't naive, okay? You guys aren't naive. But it gives you a trail, it gives you a path of where they've been, right? So phone records are wonderful. Medical records and school records, especially if you're an unmarried dad, you can't get your child's medical records, you can't get their school records. So you can get those things in discovery. If you ask your spouse or your child's mother to give them to you and they won't, you have, right, the court has, the subpoena power. You can send subpoenas there and you can get the records that way. Medical records are very good. Had a mom who I have ADHD, okay, lost a ton of weight, had an affair. I have a little bit of ADHD. Well, we got the prescription records. Gosh, well, how many doctors are giving you Adderall? How many doctors are giving you Adderall? You have doctor shopping sometimes, okay? Judges hate that, by the way, hate prescription pill abuse, doctor shopping, right? It's drugs. That's all it is. It's basically drug dealing. School records. Get your kids' school records. You'll be shocked sometimes at the attendance records. You'll be shocked at the tardies. Shocked. And you won't know because you won't give them to you. So send subpoenas and get this stuff. So those are requests for production. You can actually get documents. You can also send what's called interrogatories, questions. A common question we send are, what are all of your criticisms of Dad as a father? What are the criticisms? Basically, you're saying, what are you going to tell the judge about me that's bad? It's an opportunity for you to ask her, what are you going to tell the court? You can ask her, what exhibits do you intend to admit? Who are your witnesses going to be? So she has to answer your questions. Now, they can't be abusive, they can't be harassing, but you can ask, who have you had around my child? Who have you engaged in a relationship with that you have brought around my child? Does this person have a history of domestic violence? Does this person take drugs? What are their criminal history? What's your criminal history? You can really dig in and you can ask the questions that you need to know as a parent, and you can find out what they're going to say about you. Now, if they're interrogatories, they're sworn. They're notarized, they're signed at the bottom, they're testimony like that is in court. So if you ask for the criticisms of what criticisms do you have of him as a father? If she comes back and says, he's an amazing dad, which doesn't rarely happen. He's an amazing father. I'm so glad I chose him to be the father of my child. Then you get to court. She gets up on the stand and says, he's a horrible individual. He's abusive. He's neglectful. He yells all the time. He scares our child. You get up and you say, well, wait a minute. Ma'am, do you recall signing this document on March 1st? Yep, it's my signature. When I asked you on March 1st, he was a wonderful father. September 1st, what changed? I guess I forgot. There's always a crazy reason why. But the judges will say, okay, all right. Sometimes they won't tell you things because they want to surprise you in court. So if there comes up a document, Judge, I have a picture here of him, and he's smoking marijuana. Say, well, wait a minute, Judge. In discovery, we asked for every picture that you alleged he was abusive towards a child, that he engaged in drugs. She said that none existed. None existed. We haven't had the opportunity to look at this picture, Judge. We don't know if it's photoshopped. We don't know if it's doctored. We have no idea. And it's a copy of a copy of a copy. No. Odds are you can get that picture thrown out. Okay? So discovery, interrogatories, requests for production give the opportunity to really get in there and find out what their case is going to be about, because you have to defend yourself in there. Okay? Also, I might say that he goes to the school and he causes a fuss, and my child is so embarrassed. My child doesn't want him at the school. All right? You go to the school, talk to the child's teacher. Teacher might say, that never happened. I'm in a case right now. Mom says, it's a Munchausen case. Mom is saying, well, no, this child has asthma. The school calls the ambulance. The ambulance had to take him away. We go to the school. Was the ambulance called here? School was like, oh, what are you talking about? We've never called the ambulance here. Ask the school nurse, ask the principal, ask the vice principal, ask the child's teachers. Straight up lie. Okay? But had we not done discovery, we didn't know what she was going to say when we get to court. So she gets up on the stand. we had the deposition out. You said this. She's like, well, kind of starts to back up a little bit because she sees the teachers and the school nurse and the principal in the hallway. Well, that's what I was told. Who told you that? I don't remember. If my child is taken by ambulance from the school, I'm going to remember who told me that. All right? So, but had it not been for discovery, we wouldn't have been prepared for that when we got to court. Okay? There's also something called request for admission. Admit or deny. Admit or deny your child is a good father. Admit or deny you abuse prescription drugs. Admit or deny you have drank alcohol to the point of intoxication around your children. Admit or deny you have engaged in sexual acts with another man in front of your child. Okay? They have to admit or deny. Most states have a time frame. If you don't do this within a certain amount of time, if you just refuse to answer them, the courts can actually just say, okay, I'm going to deem them all admitted. And it's done. It's admitted for the court's purposes. Makes your case a lot easier. So if you have a case where where you can prove that behavior, go ahead and put it down in a request for admission. Make them admit or deny it. If they deny it, you can prove it's a lie. If they admit it, that's horrible for their case. And settlement value goes up. The odds of your case settling, if you can prove some of the stuff before you get in the courtroom, go up. Because truth be told, if you guys go to court, who wins? The lawyers. Lawyers win if you go to court. You're not going to win. There's no winning in family court. Now, every once in a while, a dad can go in, you can get full custody, but those cases are usually so egregious against the mother. There's so much evidence against her, but that's not the norm. That's rare. Yeah. The question is there a consequence for perjury? Okay. Not really. Now, legally, yes, perjury is illegal. The court can punish someone for perjury. But in family court, it really seems perjury just is like, well, it's family court. Somebody's not telling the truth. So people seem to get a pass when it comes to perjury in family court. Yep. Now, depositions. It's hard as a pro se litigant to take a deposition, right? You don't really know what to do. Depositions are wonderful. Depositions are amazing, right? Now, I have a reputation for doing very long, painful depositions, okay? I prescribe to the old, I prescribe to the theory there is no such thing as a stupid question. And I want you to explain. And who else knows this? Who can verify your story? Who was there? What's their phone number? I see you have your cell phone with you. What's their phone number? Okay? So, but as a pro se litigant, you're probably not going to be taking depositions, but you might give a deposition. If you're noticed for a deposition, number one, I'd recommend don't take your cell phone in there with you. Okay? One of my most painful depositions was a pro se litigant. She had her cell phone, right? She had her little boyfriend, and I said, let me see your phone. She didn't know she didn't have to give it to me, so she gives it to me. Looking through here. Oddly enough, we had just come back from a break. So I look at, oh, you text the boyfriend. I looked in there. Court reporter's taking everything down. This is true. This is true. She comes back in and she texts him on the break, and she says, we just took a break. He said, how's it going? Right? I'm going to kick this bitch's ass. I said, oh. I said, who is this bitch? She said, just looked at me. I said, oh, is this me? Right? And there was a long conversation, read it out in the record. Right? And then we moved on to her other messages between her and the boyfriend. I kind of regretted that after the fact, because after 4 hours of, I didn't even know about what emoji wars were, so we went through all the emoji wars. It was painful, let me tell you. Right? But the case's settlement value increased, and we actually settled that case. Okay? Don't take your cell phones with you. Because if an attorney says, can I see your cell phone? No. What do you got to hide on there? You have pictures of drug deals on your phone? No. Well, then let me see it. No. Okay. Don't even bring it with. Just take it. Where's your cell phone? I don't have it with me. Okay. Same thing with Facebook passwords, email passwords. All right. Mr. Smith, do you have an email account? Yes, I do. What is it? mrsmith@gmail.com. What's your password? Don't give him you don't have to give him your password. Make a judge say they have to give your password up. This is your personal information. You wouldn't believe the pro se litigants say, oh, my password, Bluebell 13. Now, and I have had that happen where they give their passwords. What's my paralegal doing? Logging in. Hey, I say, we're logging into your account right now. They say, okay, we log in. You just said it good. Don't give your passwords up. You don't have to give your, it's not an automatic thing. This is your personal information, okay? But that's, now, answer the question. Answer the question, right? Are you employed? The answer is yes. Not, yeah, I'm employed. I work over at Fort Rucker. I've been there for about 12 years. I actually worked in different places. I went from, one place to another. No, the question was, are you employed? Yes. So I tell my clients, the rule is, you hear the question, you understand the question, you answer the question, and then you shut up. What was the question? Are you employed? Yes. Stop. Right? Now, we have this tendency to want to explain ourselves. We have a tendency to want to do that. That's where you get in trouble. And I love these depositions where these women rattle on and on and on, and it's largely irrelevant, and they say, oh, am I going too far? I'm like, no, please continue. Just go. And they go on and on and on and on and on. And almost every time they say something that is detrimental to their case. So when you're in a deposition, if you have an attorney with you, they should prep you for that. But don't volunteer information. Answer the question that's asked of you, and don't volunteer anything else, okay? Okay, so after you're served with a petition, or you serve someone else with a petition, you can serve discovery with that, okay? But then it comes where you have to file an answer. Now, there's time frames on when your answer has to be filed. So when you get your petition, there should be a summons on top or some court paperwork that tells you what it is and when you have to have your answer in. Okay, generally 20 to 30 days, but you have to check your state laws and read that paperwork very well because you don't want to miss those filing deadlines. Okay? If you're going to contest jurisdiction, you have to do it before the case starts. So if there's no jurisdiction over you, before you file your answer, you could say, wait a minute now, this court doesn't have jurisdiction over me. Once you answer and enter into litigation, it could be construed that you submit yourself to jurisdiction of this court and you can't necessarily contest it later. Okay, so the question was about federal and international law as it comes to domestic relations. We're not going to hit on that. Okay, I apologize because we're really covering the nuts and bolts of more of the local civil practice stuff. It's a good question, but we just can't go down that rabbit hole.
Okay, that's fine.
So let's say that you are from Ohio and you live in a small town in Ohio, live their whole life, families live their whole life, and you and your wife lived there, you separate, she leaves, takes the kids to Virginia. Okay? She files up in Virginia. Would you rather litigate in your backyard with people who you know, who you cast your vote for? Would you rather litigate up in a state where you have no idea who their judges are? You have no idea how child support is calculated. You want some certainty. So anytime, this is a general rule, if you can litigate in your backyard, you would rather do that. Okay? Now, that said, a lot of states, child support is paid till age 18. Alabama, child support is paid till age 19. So if one of our clients gets served with a petition from out of state and he's not looking for custody, child's 17, question is, well, you know what? We can run the guidelines. They're calculated about the same way. You want to pay child support for 1 year or you want to pay child support for 2 years? That's a no-brainer. So maybe you should just litigate this and go ahead, submit to jurisdiction in Texas. All she's wanting is guidelines, child support, and if you do it here, you're going to be paying for 2 years. So it comes down to that individual case. It comes down to where you are, comes down to what court you're in. Now there's some jurisdictions that are very 50-50 friendly. There's others that are not. There's some judges who are very liberal with alimony. There's some that are not. So you're going to have to look at the two different jurisdictions, look at the facts of your case and what action needs to be litigated to decide if it's in your best interest to contest custody or just go ahead and submit to the jurisdiction of another court. Okay? All right. So, or if you want to file a motion to dismiss, if this was years ago, had a case where parties were involved in a relationship, child was born, they did a DNA test, child was not his. Well, 6 months later, she files a petition. And it was through the Department of Human Resources, our CPS service. They did the test, and he was not the father. She still filed for child support. We did a motion to dismiss, attached an affidavit from the DHR worker, and the paternity test. Judge dismissed it. Okay, so if you're going to file a motion to dismiss, you want to do that too before you file your answer, if you have good cause. Yeah. But go back. The question is, sometimes emergency situations come up. So where you really don't have time maybe to retain counsel, to do a motion contesting jurisdiction. Sometimes you get notice, hey, you have court this afternoon, or you have court tomorrow. These things come up quick. Now, some states say that your motion to dismiss has to be in writing, signed by you and your attorney. Some states say it can just be an oral motion, so that depends on the state law. But so in Alabama, for instance, there's nothing about motions to dismiss in terms of being in writing. You can do them orally. Florida does have rules regarding how their motions to dismiss have to be filed. They have to be in writing and signed by the attorney and the party. So the answer is yes, you can do that, but you have to follow your state law. If it's just in a one-page affidavit, maybe you can knock it out, or what I say affidavit, a verified pleading, you can go ahead and you can even handwrite it. But as long as you meet the requirements that the court puts out for those motions, you can do it orally, or you might have to just do it in writing. It really depends on the state laws. All the state laws are different.
Like, subscribe, and click the notification bell for new videos. To learn more about legal services provided by a sponsor of TFRM, click the links in the description section of this YouTube video or on one of the video links on your screen.